I'm going to pass the torch over here to Tana Downing.
So my name is Tana Downing. I'm a civil rights advocate litigator. I'm here in D.C. and we're pursuing a number of major opportunities to be able to correct some of these gross injustices that are going on here in America. So with regard to the child issue, this is very specific, and we need to make sure that we apply the constitutional mechanism that would be in force and effect. So in 1984, the United States Supreme Court came out in a case called Roberts versus United States, and they said that you have the right to intimate association that's protected as fundamental under the First Amendment. Okay, so what does that mean? It means that you have the right to have an intimate familial relationship with your child, and your child has the right to have an intimate familial relationship with you without governmental interference. And that was found to exist within the First Amendment because the First Amendment identifies those rights that are guaranteed by God and given to you by God. So you have the right or the freedom to speak, you have the freedom of religion, you have freedom of conscience, freedom to press, right? Those are all given to you by God. You don't have the God-given right to bear arms because that's a civil right. God gave you the absolute right, the freedom to be able to defend yourself, but the way in which you choose to defend yourself is granted by man. Therefore, the right to bear arms is actually a civil right, not a freedom. Okay, so, but the Supreme Court did identify the right to intimate association guaranteed as fundamental under the First Amendment because it's given by God. God made you a mother or father, and as a result, only God can take away your mother or fatherhood. And so until the day you die, you will remain a mother or a father because God gave you that right. Therefore, government cannot take it from you. So when you deal with the First Amendment and fundamental rights, there's very specific elements to it. The only way that you can deprive a person of a right guaranteed by the First Amendment that's fundamental is by what's known as strict scrutiny. And that requires the compelling state interest test. Now, there's 4 levels of judicial test. The highest or strictest would be strict scrutiny, requiring the compelling state interest test. The lowest is what's called the discretionary test, meaning the judge can use his discretion to deprive you of a right, okay? But you cannot use discretion with regard to a fundamental right. You must apply the highest test. Now, when you deal with strict scrutiny, the interesting thing is that 90% of the time, when a deprivation is compared or measured against strict scrutiny, it's determined that the state has exceeded the power or authority statutorily conferred upon it by the Constitution in their act of deprivation. So it's a very, very high measure to reach. It's a very difficult measure to reach because basically the state has to go out and prove that there's absolutely nothing else that can be done except for deprive this person of his right that was given by God. And obviously there's lots of different options that there are. Put the person through counseling, take the family together, help them find a job or secure housing. There's other options that exist. Therefore, the act of deprivation would be unconstitutional when the judge applies his discretion. Okay. Now, abusive discretion is what occurs. So when any public official abuses any discretionary authority with which they're invested in law, there are a number of crimes that come from that. Automatically, it's the crime of perjury because they failed to fulfill the promise that they made upon entering into their office. That's codified in the Constitution of the United States. Another crime is extortion because they are compelling a result through illegal means, through the unlawful application of their discretion abusively. And the third would be oppression because they're applying the law unequally among people within our society. Those are 3 automatic crimes. And those crimes are per se, meaning that you don't have to prove that they intended to breach the obligation simply by virtue of the breach. All elements of crime have been met because their willfulness and knowledge derives from the promise that they made. So when you make a promise to do something and you fail to fulfill that promise, then obviously we don't have to prove that you intended to do it because you already made the promise. So when judges enter into their office, they make a promise, and the promise can be codified within the Constitution. The elements of the promise are there when it says in Article 6, the judges shall be bound thereby, everything in the Constitution or laws being stated contrary notwithstanding. So when they make a promise to do what the Constitution says and then fails to do it, that would be the crime of perjury. And perjury, of course, is a violation of public trust. And when you violate public trust, you can no longer be trusted by the public to fulfill your obligation. Therefore, according to Article 3 of the United States Constitution, the judges, both of the United States and of the several states, shall maintain their office while in good behavior. And good behavior is defined as the avoidance of criminal behavior. So when you judge decide to engage in criminal behavior, especially criminal behavior that involves public trust, you yourself are discharged immediately. That is a per se crime. I mean, we don't have to have a finding of facts to determine whether or not you intended to breach your obligation. Simply by virtue of the breach, all elements of crime have been met. So now we have a situation where there is an abuse of discretion. So to determine abuse of discretion, we can go to the United States Circuit Court Handbook. And the Circuit Court Handbook identifies a 2-part test to determine whether or not abuse of discretion has occurred. The first part is, did the judge render a decision, did he apply the incorrect test? Well, I just told you that he did. He was supposed to use the highest test, strict scrutiny. He was supposed to prove that there's nothing else that can be done but deprive this individual of this right guaranteed by the Constitution of the United States. When he failed to do so, then he obviously did apply the incorrect test because he used his discretion abusively in order to deprive the individuals of the right. Now, the second part is any erroneous view of the law is an automatic abuse of discretion. Now, an erroneous view of the law is that in the judge legal contemplation that the lowest form of law, being a state statute that permits him to be able to deprive a person of right guaranteed by the Constitution, is in legal contemplation superior to the provisions of processes codified in the Constitution of the United States. That would be an erroneous view of the law. Therefore, an automatic abuse of discretion has occurred. We have we have tens of thousands of judges across America today that are acting illegally and unconstitutionally in violation of the promise that they made to the people of the United States and the states in which they're employed. So we need to get this addressed, and that's what we're here to do. So over the next few weeks, we're going to be bringing to attention the issues that I brought across, and I served to 32 attorney generals across the United States of America, bringing this to the forefront. And now we're switching gears over into the child aspect. Remember, the TERS logo, or the TERS slogan is one question, one action, every prisoner. There's lots of different types of prisoners. We're going to get them all back home to their families so they can receive the love and support they need to heal from the traumatic experiences and for America to finally get out of this institution of slavery once and for all. Thank you guys so much. God bless you.
To my love, took it down. Climbed a mountain and I turned around, and I saw my reflection in the snow.